Welcome to Employment Law This Week. I'm George Whipple. Collecting workforce data just got a lot more complicated for employers following anti-DEI executive orders signed by President Trump. The orders use strong language to address, quote, illegal DEI, end quote, in government and among private employers. And companies are concerned that collecting or reporting demographic data could attract unwanted attention.
Employers should balance the benefits of collecting demographic data with the risk that that data collection might somehow implicate the executive order's prohibition on illegal DEI. A few things for employers to keep in mind. One, be transparent. Make sure you are letting your employees know why you're collecting data and how you're going to use it. Another thing to think about is to make sure you're using that data for lawful reasons. For example, collecting race and gender data for EEO1 reports or collecting other types of demographic data to analyze hiring and promotion trends. Ultimately, an employer should choose an approach that is consistent with their risk tolerance level.
Employers need to carefully consider their obligations under state and local law that may conflict with the executive orders. For instance, some employers who are contractors with government contracts from state and local agencies may still be subject to affirmative action obligations, even though they are unwinding their federal affirmative action programs. In addition to the many considerations that U.S. employers have, international companies also have to consider whether their home country rules conflict with the executive orders and whether those rules require disclosures publicly that might attract negative attention in the U.S. or potential litigation risk.
Public companies have unique considerations for reporting when it comes to their board of directors.
Currently, SEC rules require that a public company disclose in its proxy statement whether the board or the nominating committee considers diversity in choosing its director nominees. And also, SEC rules require the company to disclose whether or not it has a policy about nominee diversity. These requirements have not changed since the executive orders came out.
Some employers worry that missteps around demographic data could leave them vulnerable to enforcement action.
The EEOC's acting chair has said she intends to focus on race and gender discrimination, anti-American national origin discrimination, as well as religious harassment and bias. So I think we can anticipate seeing an uptick in charges related to these areas. As far as what the administration will view to be illegal DEI remains far from clear at this moment. But at the end of the day, employers have and continue to be bound by the non-discrimination provisions of Title VII, as well as other state and federal laws. So those should continue to be our guiding principles going forward.
Thanks, Jill and Briar. Another story that's currently developing could have major implications for questions around the authority of independent agencies. A federal judge in D.C. has ordered the reinstatement of National Labor Relations Board member Gwen Wilcox. President Trump ordered Wilcox's removal when he took office, but the district court judge ruled that the president does not hold that authority. Thank you very much for watching, and we'll see you next time.